Hey besties, welcome back to my channel. So Judge Liman just dropped a scathing ruling against Blake Lively. And wow, if this is any sign of what's coming with future motions or a judgment on the pleadings, her entire case could be hanging by a thread. The judge just tossed Jed Wallace completely out of the case. No more amendments, no second chances, nothing. He basically said the New York court has zero jurisdiction over Jed Wallace. Not a zilch, nothing. This order came down this afternoon. And according to the judge, the case in the Southern District of New York is dismissed with prejudice. Now, she can technically refile it somewhere else, but only in a place that has proper jurisdiction over Wallace. The problem? The version of her lawsuit that just got thrown out was built heavily on a bunch of theories trying to justify New York jurisdiction, so she basically have to rebuild the whole thing from scratch. One part of the order touches on her FEA claims, the ones about workplace harassment and retaliation. The judge essentially said that Blake's FEA arguments against Jed Wallace fail, because they're really just defamation claims dressed up as workplace discrimination. In other words, they're trying to sound like retaliation but actually read like defamation. In the ruling, he mentions that Lively lists 3 separate reasons she thinks New York has personal jurisdiction over Wallace. Conspiracy jurisdiction under CPLR 302-2, based on the idea that Wallace was part of acts in New York tied to a conspiracy. Another theory saying Wallace caused injury to her in New York, even though he acted outside the state, and should have expected those consequences since he earns income across states. And a third, again about conspiracy, that Wallace's co-conspirators did business in New York so their actions could be pinned to him. The judge said flat out, nope. She didn't prove jurisdiction under any of those. Which means Wallace is out. The New York court can't touch him, and honestly, I think this says a lot. Because the judge seems to be poking major holes in her story about retaliation and what she's calling employment backlash. When you read it, it really sounds more like defamation than any kind of workplace discrimination. And that's a big deal because this ruling could spill over and affect all of her other FEA claims against the rest of the defendants too. Here's what he basically wrote. The Wallace defendants argued that Lively's 2 main claims against them, false light invasion of privacy, and aiding harassment and retaliation, both sound exactly like defamation. The court agreed. He said the real issue at the heart of her lawsuit is damage to her reputation. So these claims are based on reputational harm, not workplace harm, which means they can't be used to establish personal jurisdiction under this law. This is huge. He's basically saying the injuries Blake described, all of them, aren't about her job at all. They're about how people see her. That's a reputational injury, not a workplace one. And that's a serious problem for her entire case, not just this piece of it. He even pointed out that her whole complaint is packed with language about her reputation, how the public views her, and how media coverage damaged her. She even tied her financial losses to those reputational issues. So the judge said there's no separating the two. All of it flows from reputation, not employment. Because of that, the court had no trouble deciding this was plain and simple, a defamation case. And under New York law, you can't disguise a defamation claim by calling it something else. You can't take defamation and rewrap it as harassment or retaliation just to make it sound stronger. And that's exactly what the judge says Blake did here. She's repackaging. The harassment and retaliation parts, the aiding and abetting, they're all just defamation in disguise. Even the invasion of privacy section, he says, is really just another form of defamation. The judge also pointed out that all the injuries Blake mentioned in her complaint were purely about her reputation, not her actual work environment. That's key, because under employment law, reputational harm doesn't count as a workplace injury once your professional relationship with the company is over. He wasn't buying her argument that these claims weren't about defamation. She tried to say her false light claims weren't tied to any defamatory statements, so they shouldn't be treated like defamation. But the judge didn't fall for it. He wrote that you can't just avoid defamation laws by pretending you're not talking about specific false statements. What matters is the nature of the harm, not the wording or form of the complaint. He even quoted a prior case, saying that when the harm is damage to someone's reputation, that's defamation, no matter how you label it. Basically, if it looks like a duck and quacks like a duck, it's a duck. Now, what he said about her FEA retaliation claims was just as interesting. He acknowledged that most FEA retaliation cases have nothing to do with defamation, but he said this one is the rare exception. In this situation, every retaliatory act Blake described was actually about hurting her reputation and credibility, not her workplace. He noted that the only real adverse employment action she mentioned was this supposed coordinated campaign to make her look bad during her film promotion. So again, that's publicity, not employment. Her claims just loop back to the same idea. People damaged her image. And according to the judge, that's defamation, not discrimination. So basically, what the judge is saying is that this whole smear campaign Blake keeps referring to isn't actually a workplace issue at all. It's all about her public image. She's claiming it hurt her business and reputation, but not her actual job or employment status. That's a major distinction, because if it's defamation, it doesn't count as a workplace injury under FEA. And that's something Wayfair's lawyers can now use when they go for summary judgment. They can argue, look, the court already ruled this sounds like defamation, not an employment issue. That could get the rest of her case tossed too. On page 21, the judge wrote that the fairest way to read her allegations is that every single harm she mentions comes from damage to her reputation. Even when she lists business and professional harm, it all connects back to the same source, people seeing her in a bad light. He gave examples. She canceled public events, turned down a Target corporate appearance, skipped hosting Saturday Night Live's anniversary episode, and backed out of promotional gigs for her own companies. All because of the negative press. The judge said those are reputational consequences, not workplace ones. He added that the negative media coverage also allegedly caused her hair care line sales to drop. But again, that still comes from bad publicity, not discrimination. And under the law, when lost business or career opportunities happen because of reputation damage, that's a defamation issue. Plain and simple. So what this really means is that not just Jed Wallace, but all the other defendants could end up benefiting from this ruling. When they file for summary judgment, they'll likely argue that Blake's entire case is built on reputational harm, not workplace retaliation. And here's the thing. Under employment law, reputational harm doesn't meet the standard for an adverse workplace event. It's not the same as being fired, demoted, disciplined, denied work opportunities. To qualify as workplace retaliation, it has to be tied to your job in a direct, measurable way. But Blake's list of supposed injuries? The judge said they were all about loss of professional standing, damage to reputation, accumulated bad press, and interference with future income. Those aren't employment actions, they're public image problems. He even made it clear. Those kinds of issues sound more like defamation than discrimination. And that's a huge blow to her FEA claims because once you remove the smear campaign from the equation, the remaining claims, like sexual harassment, are apparently time-barred under federal law. She said the last incident happened in May 2023, and there's a 300-day limit to file under that law. So that means most of her case could be legally dead already. It's honestly devastating for her case overall. And here's the kicker. The judge made this ruling a whole week before the summary judgment motions were even due. That gives the defense plenty of time to weave this ruling into their arguments for dismissal. And remember, summary judgment is all about showing that there's no real dispute about the facts, just a question of law. So now, Wayfair's lawyers can argue. The court already said these claims are basically defamation, not workplace retaliation. Case closed. They won't even have to touch the extra jurisdictional stuff. Honestly, this ruling is a huge win for the defense. It strengthens their position going forward, and makes it way harder for Blake to prove her claims. The judge also noted that Blake herself connected her emotional distress directly to the smear campaign, the bad press and online attacks, all of which are reputational harms. That means even her emotional distress claims could be treated as defamation under New York law. So anytime she said she was put in a false light, or shamed, or that her reputation was destroyed, the court sees that as defamation, not FEA retaliation or workplace discrimination. Under the law, those are speech-based injuries, not employment ones. Then he went a step further and said that even her claim about being hurt by a frivolous lawsuit filed against her is still reputational, not a workplace harm. Which suggests that he's not buying the idea that those legal fees she's demanding, $47,100, are justified either. It also looks like he's relying heavily on New York law, not California law, which is even stricter about repackaged defamation claims. That's another big hurdle for her. Now here's where things get even more complicated. The court hinted that Blake's whole case might collapse into what lawyers call a defamation preemption problem. Basically, if all your claims, like retaliation, interference, or emotional distress, come from the same alleged act of defamation, the court can throw them all out as duplicative. In other words, you can't sue someone under 5 different laws for the same alleged smear campaign. So when Blake's team framed her injuries as reputational harm and public humiliation, the judge likely saw that as multiple versions of the same thing. That's a legal red flag. Even worse, the judge mentioned that she failed to show any tangible change in employment status. That's the standard phrase courts use to dismiss retaliation cases. If you weren't fired, demoted, or denied opportunities directly because of your complaint, the law says you didn't suffer retaliation, at least not under the FEA or Title VII. That means the only real claims she might still have left are the defamation ones. And those are incredibly hard to win, especially when the defendants are public figures or corporations with free speech protections. And if the judge eventually rules that her claims are time-barred and defamation-based, she could end up with her entire federal case dismissed, leaving only the possibility of a much smaller, state-level defamation fight. So at this point, Blake's legal strategy is hanging by a thread. If the defendants win summary judgment, and they very well might, the court could dismiss most, if not all, of her federal claims. That would mean no trial, no jury, and no real chance at damages under the Fair Employment Act. Her only remaining route would be to push the defamation angle, but even that's risky. To win, she'd need to prove not only that the defendants spread false statements, but that they did it with actual malice, meaning they knew it was false or acted with reckless disregard for the truth. That's a nearly impossible standard when you're dealing with corporate PR or internal investigations. Plus, the defendants can argue that everything said about her, whether in media, online, or court filings, is protected opinion or privileged communication. That kind of defense shuts down most defamation cases before they ever reach a jury. So in short, this ruling is a major turning point. The judge essentially stripped away the emotional and reputational layers of Blake's complaint and left her with a very narrow, technical path forward. If her lawyers can't pivot fast and show real, concrete workplace retaliation, not just bad press or embarrassment, her entire case could be dismissed by early next year. It's a harsh reality, but legally, this decision shifts the momentum entirely in the defendant's favor. So, in the end, this ruling doesn't just weaken Blake's case, it practically rewrites the battlefield. What once looked like a strong retaliation and harassment lawsuit is now being reframed as a defamation dispute, and that's a whole different game. Unless her team can produce solid evidence of actual workplace harm, something beyond reputation and public image, her case might not survive the next round. For now, the defense is in control, the clock is ticking, and Blake's legal options are running out. So, what do you think? Share your thoughts down in the comments. Don't forget to give this video a thumbs up, hit that subscribe button if you haven't already, and tap the bell icon so you never miss an upload. Thanks for watching. See you next time, besties. 2 hearts.